Users of Celsius worry about personal information being released in bankruptcy case. Welcome to CryptoLink channel. If you love getting news and updates about cryptocurrency, join our community by subscribing to our channel. You can tap the bell icon to never miss our new videos. If you enjoy our channel, kindly like and share it with your friends. October 24, 2022. According to a tweet from Cointelegraph, a news site that published the loss amounts of Celsius clients isn't making the bankruptcy proceedings any easier. On July 13, 2022, the cryptocurrency lending platform Celsius submitted a Chapter 11 bankruptcy case. Even though the Celsius case includes digital assets, the United States Bankruptcy Code still applies to it, according to the Bankruptcy Court for the Southern District of New York. However, since Celsius declared bankruptcy, a number of strange things have happened. Martin Glenn, the chief bankruptcy judge for the United States and the judge in charge of the Celsius case, said on October 17 that the court would seek advice from other jurisdictions. Glenn clearly stated that American courts are not bound by legal standards that apply in the United Kingdom. However, he pointed out that these might be convincing when addressing any legal concerns in this situation. While the Celsius issue will be handled in accordance with American bankruptcy regulations, Glenn still wants to decide how the Celsius matter ought to be handled. Additionally, hundreds of Celsius users' personal information have been made public in court records relating to the platform's bankruptcy procedures. Names of clients, account balances, transaction dates, and other information are included in a significant financial disclosure form submitted on October 5. The U.S. Bankruptcy Code prohibits the disclosure of this information, which may have surprised Celsius consumers. Licensed Canadian cryptocurrency exchange WonderFi Technologies' General Counsel and Chief Legal Officer, Adam Garrettson, said to Cointelegraph that the bankruptcy process should be transparent, accessible to the public, and open. He also stated that it is a powerful method of preventing any inference of improperness by the courts, the parties to the case, and other interested parties. As a result, courts have the authority to ask for information from the bankrupt corporation and issue orders requiring it to reveal material that is in the public domain. Although it is remarkable that committee inquiries have turned up so much data about customers. In an essay from the National Law Review released on October 18, this argument was emphasized, which claims that a lot more information regarding the debtor's financial operations, insider conduct, and the course and direction of the bankruptcy case has become public as a result of debtor filings and committee investigations. According to the article, despite the fact that a great deal of private information has been made public, there is still no indication of how claims would be evaluated and reimbursed in this case. Unintended consequences affect Celsius users. The disclosure of private information has added to the stress experienced by Celsius customers as they wait for rulings from the U.S. Bankruptcy Court. Customer information was just exposed on a website named CelsiusNetWorth.com, which only served to worsen the situation. Users of Celsius can be found by name on the website, and their losses in cryptocurrency holdings can be viewed along with them. The website also has a leaderboard that displays users according to rankings for the biggest losses, as if this weren't horrible enough. After user information is displayed, a Twitter button appears on the page, allowing users to tweet the information. The AMX founders of CelsiusNetWorth.com stated to Cointelegraph that the website was developed utilizing information that was made available to the public as a consequence of Celsius legal activities. The insider added that while the material on the website must not be regarded as a leak, it's possible that its release could have effects similar to those of the Ledger data leak, which happened in December 2020. AMX said that Celsius decided to make this information available to the public. It is a fact, whether we like it or not. In terms of bankruptcy proceedings, Garrettson asserts that these kinds of websites are unusual. He did note that high-profile incidents that draw particular attention from the media or the focus of a certain community could be the cause of such occurrences. In fact, AMX pointed out that the purpose of CelsiusNetWorth.com was to generate buzz rather than to make it simple for people to learn about the Celsius creditors' losses. Although nothing about these occurrences is amusing, one example of a humorous method is the Twitter button. However, this generates a buzz to draw attention to a number of things, including the truth that this data has been made public, the quantities lost, or the financial standings of particular strategic Celsius employees. Whatever the case, many Celsius users have had unintended outcomes as a result of the data made public through the CelsiusNetworth.com website. Lessons learned. While it is regrettable that CelsiusNetworth.com was developed using user data that was made publicly available, this shows the requirement for more regulatory clarity and education in the cryptocurrency industry. DePaz indicated that at first, he thought of Celsius as a reliable cryptocurrency loan platform. The website and the frequent Ask Me Anything parts made Celsius somewhat intriguing. They claimed that the platform was licensed, which gave the impression that Celsius was administered by someone who understood what they were talking about. Carvalho noted that he envisioned Celsius as a chance to secure his family's financial future. Celsius would frequently offer, "Put your funds with us and we'll give you yield," during the Ask Me Anything sections. At the time, I was unaware of the risks. WonderFi Technologies CEO, Ben Samaru, informed Cointelegraph that the Celsius case stands out because originally customers weren't given access to a lot of transparency. He also stated that the risks associated with the high profits that were promised could not have been revealed to or comprehended by the clients. This may have been the case for new users in particular, but it also may have affected individuals who were already engaged in the sector. The current condition of the Celsius lawsuit also shows that virtual asset platforms are still bound by traditional U.S. laws. Garrettson clarified this by pointing out that this lawsuit is just one more illustration of the fact that official, comprehensive regulation of the crypto asset industry in the U.S. is still pending. He added that, regardless of the existence of any crypto-specific laws, conventional legal principles including property, contracts, and bankruptcy law still apply. Garrettson observed that as a consequence, individual judges who are probably less knowledgeable with the industry would decide the conclusions of the Celsius case in real time rather than panel of experts or a Congress. This highlights the urgent need for comprehensive and coordinated regulation, especially when it comes to the supervision of centralized trading platforms. That's it for our today's video. So, what can you say about the news? Let us know about it in the comments section down below. Thanks for tuning in to CryptoLink. We are always excited to provide you with news and updates about cryptocurrency, and if you like this video, please click the like button. See you on the next one.